Cases on the docket scheduled for oral argument this morning. Our first case is Alachua County Board of County Commissioners and Alachua County Supervisor of Elections versus Keith Perry, Kimberly Horde, Jose Lopez, and Charla Head. Counsel, are you ready to proceed?
We are, Your Honor.
You may approach. We will allocate 20 minutes per side for the oral argument, counsel. Would you like to reserve some time for rebuttal?
I'm going to try to reserve 5 minutes, Your Honor.
So noted, Madam Clerk. You may continue, counsel.
May it please the Court, I'm Peter Webster of Carlton Fields, and I'm here on behalf of the Alachua County Commission and Supervisor of Elections. With me at council table is Sylvia Torres, the Alachua County Attorney. Because we believe we prevail on the statutory construction issue, I'm not going to spend a lot of time on subject matter jurisdiction unless the court has questions. We believe we've adequately covered that issue in our briefing, and so we'll rely on the briefs absent questions from the court for the court to decide whether the petitioners pled the existence of an actual present bona fide dispute requiring the trial court's intervention, or whether they merely pled a request for an advisory opinion based on the possibility of legal injury if the referendum passed in November. With regard to the statutory construction issue,
Oh, I'm sorry, I do have a question
Yes.
on the jurisdiction part. So as Justice Polston indicated in his concurring opinion in Roberts versus Brown, circuit courts routinely consider pre-election cases when there's a constitutional challenge. Here, the trial court resolved the issue on statutory grounds. Is that the distinction that you think is important here?
Well, first of all, Your Honor, I think that Justice Polston was concurring and dissenting in the Roberts case. He was the sole dissenter. Mm-hmm. And I think if we read his opinion carefully, we find at page 686 that from his analysis of the election cases you adverted to, he was pretty clearly of the opinion that the court, the majority, was saying in its opinion that you just can't seek declaratory relief in those kinds of cases. So I'm not sure that the opinions that the petitioners relied on survive subsequent to the Roberts opinion.
Do you think he was limiting that to, or the majority at least, to citizen initiative petitions where the Supreme Court does have a special place?
I don't think, Your Honor, that that's the way Justice Polston was reading it. What Justice Polston said, and this is at page 680 of the opinion. Oh, I'm sorry, that's the majority opinion. What Justice Polston said at page 686 of the opinion, after he discussed the cases you mentioned, he said the majority justifies its decision in part by referencing the rule of law that a circuit court does not have jurisdiction to render an advisory opinion based on hypothetical facts. So he's clearly reading the language at page 680 of the majority opinion as stating that you can't attack these kinds of referenda, whether citizen initiatives or just normal referenda, pre-election because of necessity. You're seeking an advisory opinion based on facts that haven't yet occurred and in fact may never occur.
But didn't the Supreme Court in 1958 in the Dade County v. Dade County League of Municipalities case, I mean, I don't understand how they got there after following Duval County versus Jennings, which was a special case dealing with receivership of or conservatorship of trust funds. Be that as it may, they did say in the subsequent case in Dade County that they basically that seemingly approving looking at this stuff pre-election, because they called it, what was it, a vain and useless thing if it was an invalid proposal in the first place or proposition in the first place. So I guess going back to Judge Ray's question, is it the constitutionality versus something else that's the distinction there, or where are you headed with that? I know that you said that you've already covered this in the briefing, but I think it's an interesting issue.
It is, Your Honor, and I'm not sure that the Dade County and Duval County cases survive Roberts, but assuming without conceding that they do, and that you can still challenge a proposed ordinance, if in good faith you claim it's unconstitutional in its entirety on its face, that's not what we have here. While the petitioner's arguments are all over the map in the trial court, the only two constitutional challenges that can be fairly read from the emergency petition both relate to Article 8, Section 1G of the Constitution, which says that the governing body of a county operating under charter may enact county ordinances not inconsistent with general law. Their first challenge in their petition was that the proposed amendment would violate general law because, and this is a quote, Section 124.011.3a only authorizes the Board of County Commissioners to submit a proposition calling for single-member representation and does not authorize the board to submit a proposition calling for at-large representation. Clearly, on its face, that assertion fails, so it's not a good faith assertion. And it clearly fails because 124.011.10 clearly provides that a county choosing to opt for single-member election districts can opt back.
Sure, but what's the difference, though, between when you're looking at the constitutionality of something? Typically, we're looking at a Florida statute and questioning whether it's constitutional. So you have the superior law, the Constitution, and the junior law, the statute, and there's a conflict between the two, and you have to resolve that conflict. That's Marbury versus Madison and everything since then. But when you're looking at a local government and you have an ordinance, and there's potentially a conflict between the ordinance and a Florida statute that the Constitution provides is superior, and I'm not, that's a separate question, but assuming that there's superiority between the statute and the local ordinance, what's the difference? It's still a conflict where that has to be resolved.
Well, first of all, there is no conflict between.
I don't mean to.
There is no conflict between the ordinance and the Constitution, because the ordinance, if passed, would simply provide for a return to at-large elections.
Right. But what about the ordinance and the statute that we're talking about? So if there's a conflict between the two, and the argument is that the statute prevails, it's the same analysis as if you were looking at the constitutionality of the statute.
To the extent that they have pleaded a problem between the ballot referendum, not the ordinance, the ballot referendum, which we submit is not what you should be considering. But to the extent they argue there's a conflict between the ballot referendum and the statute, that only exists if they're right that Section 124.011.9 applies to a decision to go back to at-large voting. And we think it's pretty clear, for the reasons I'd like to get to, that that's facially not a valid constitutional issue either, because it's clear subsection 9 does not apply here.
Counsel, I believe I understand your issue regarding the statutory challenge, but the petitioners also raised a constitutional challenge in the proceedings below. Is that correct?
Are you talking about their claim that the local bill is irreconcilable with what was done?
The trial court.
Their third issue?
The trial court particularly said that it did not reach the constitutional issue raised by the plaintiffs below. Regarding your jurisdictional argument, would the trial court have had jurisdiction to grant injunctive or declaratory relief in this case had it found a constitutional violation in the referendum as opposed to a statutory violation?
Well, I've already discussed the only valid constitutional arguments they made in their petition. They made a whole bunch of additional constitutional arguments in a supplemental memorandum that they filed the night before the hearing, to which Alachua County and the Supervisor of Elections objected. And so those issues have nothing to do, we submit, with whether there was a valid constitutional claim made, because they're not part of the petition. And maybe that's what you're talking about.
Specifically, did the trial court have jurisdiction to reach a constitutional issue in this case, assuming for the sake of argument that the plaintiffs raised a valid constitutional issue?
Assuming for purposes of argument that the plaintiff asserted in its petition a valid constitutional issue, that the ordinance, the proposed ordinance, would be unconstitutional on its face and in its entirety, the court may have had jurisdiction to consider that. The older cases seem to suggest it would. We submit to you that Roberts strongly indicates that's no longer the case. But my point is, even if that is still the case and the court would have had jurisdiction, there are no good faith arguments in the petition that the ordinance, the proposed ordinance, on its face and in its entirety would be unconstitutional.
Did the legislature have the authority to enact the special law that was raised by the appellees?
I don't know the answer to that, Your Honor. We're assuming it had that authority for purposes of this appeal.
So in that special law, the legislature directly amended the county's charter, right?
No. They amended it effective as of the electors voting by majority vote to make the change.
Right, the conditional amendment.
Yes.
And has that gone into effect now?
It did. As a matter of fact, in the 2024 general elections, 2 of the county commissioners were elected in single-member districts.
Right, but the special law that's been, sorry, I forget the bill number, but the enactment from
1493.
Yeah, from 2022. That law is now in effect, isn't it?
Until pursuant to section 124.01110.
Yes, and that's my question. So are you prepared to argue whether the county voters, the county commission and the county voters can override a direct special act of the legislature amending the charter?
I am prepared to argue that, yes.
Can you explain why that might be, and then what is the point of the legislature having political subdivisions in the state of Florida?
Sure. First, petitioners made the same argument in the trial court. The trial court rejected that argument, concluding that because of section 124.01110, the commission could again place the issue on the ballot for a return to at-large elections. Petitioners didn't challenge that in the trial court. They've not taken a cross appeal here. In fact, in their answer brief, they state the trial court was correct. Therefore, they've waived any argument that the special act prevents a return to at-large voting. Secondly, they failed to identify any specific language in the bill which supposedly conflicts with the referendum, because there is none. The referendum clearly does nothing more than direct that the matter be submitted to the Alachua County voters. That was done. There's nothing in the special act to suggest that they couldn't return if they wanted to at-large voting. And in fact, if the special act did that, it would almost certainly be unconstitutional in violation of Article 8, Section 1E of the Constitution, and of course would be irreconcilable with Section 124.01110, which expressly provides for a return to at-large voting. Third,
Counsel, what is the practical effect of an affirmance of the trial court in this case?
an affirmance on what ground, Your Honor?
Yes, affirmance. If we affirm, what's the practical effect?
Without any analysis? If you affirm without any analysis, you know, that I presume that the 2024 election would be considered invalid, and single-member districts would still be in place. But, you know, the statute that the trial court relied on simply does not require that the language in subsection 9 be used to return to at-large voting districts. The subsection 10, which is the controlling provision, expressly states that a county adopting one of the propositions set forth in this section may thereafter return to the procedures otherwise provided by law by following the same procedure outlined in subsection 3. The petitioner's argument is that although that's what the statute says, it can't really mean that. It must really mean that you can return to at-large voting only by complying with all of Section 124.011.
Then, counsel, is it your position that Section 124.011 does not provide any required language if a county wishes to revert to at-large voting from a single-member system?
That's exactly our position. And if the legislature had intended to require a county wishing to return to at-large voting districts to comply with all of the provisions of Section 124.011, why on earth would it not have said, instead of what it did say, which is you can return by complying with subsection 3, why would it not have said a county adopting one of the propositions set forth in this section may thereafter return to the procedures otherwise provided by law by following the same procedure outlined in this section? They use section when they meant to refer to a section, but they used subsection 3 when they said what had to be complied with. And the reason for that is because there's already a provision in the Florida statutes that deals with referenda and the wording of referenda. It's Section 101.168, and it's entitled Ballots and Referenda.
Thank you, counsel. You're well into your rebuttal time.
Thank you. I'll reserve what I have left.
Please, the court. Good morning. It's a little bit daunting to try to inform this august body about statutory interpretation, but I'm going to do my best to enhance the analysis from the briefings, and in particular, just to give you one keyhole to look at this statute through, and I think...
Counsel, regarding statutory interpretation, what authority says that a trial court may grant the declaratory relief in a pre-election case based on a violation of a statute as compared to a violation of the Constitution?
So in the briefs, we cited a string of cases where circuit courts have challenged the wording in ballots and initiatives, not constitutional citizens amendment initiatives. And we can presume that the number of cases reflected in the DCA opinions is just the tip of an iceberg of cases that either were PCA'd or weren't appealed at all. So it's a commonplace procedure in Florida. But the statute is a ladder. The statute has a little front door, 2 sections, subsection 1 and 2, and it's got an attic, which is 10 and 11. And subsections 3 through 9 is a ladder. The first 2 subsections relate to the conversion between at-large and single-member districts. It's appropriate that they would come first. The statute was written initially when no counties were single-member districts. It was the only way you could get there. And so every county that wants to go to single-member districts has to first proceed through subsections 1 and 2. Up in the attic, you have 10 and 11. That's what happens after you've completed and you've gotten to single-member, and you might want to go back. But 3 through 9 is the ladder. That's the process. You have to step on every rung. And if you look at the language, you will see that's exactly what the legislature intended. It's unmistakable. Once you see it, you can't unsee it.
Yeah, but actually, isn't it the opposite? Like, when I look at 9A, what I see is it is part of the initial process, and that's what, so when it says each to be elected from single-member districts, to be elected in the future after the transition. So it's speaking in the future, if the county follows this process and then they go to single-member districts, if you want to then, at that point, that's when 9, so 9 applies initially, not subsequently.
That's a fascinating point, and I think that really goes to the sort of beautiful symmetry of this statute, because that language goes either way. The legislature didn't come up with a whole bunch of different configurations. They came up with one set of language that voters can either say yes or no to, and it works either way. It's bi-directional. And that's part of the magic of the ladder, Your Honor. If you look at sections 3 through 9, you will find not one reference to unidirectional language. You can't find it. It's not in there. In some cases, they have to be a little inelegant even in the language in order to accommodate both directions. So, for example, they call it the proposed revision instead of the petition to shift to single-member districts. They use different variations and synonyms for that, but they never specifically reference going either one way or the other. There's some more magic language if you want. If you
I mean,
look,
subsection 3 does.
subsection 3 describes how the shift is initiated, either way.
No, it actually says a proposition calling for single-member representation.
Well, that's true, and that's the transition sentence.
So that's going one direction.
That's the
That's
transition
the initial
sentence.
process, which you've described, that's, the...
The latter.
Yeah, the latter part.
Yeah. So we know that paragraph in particular was intended to be bidirectional because that's the one that subsection 10 sends you back to. So
Well, I mean, the reference is to the process that follows the initial statement in subsection 3, not the whole subsection 3. The whole subsection 3 doesn't talk about the process.
well, that gets us into
Paragraphs A and B do.
Yeah, that gets us into the fascinating language of subparagraph 10, which I'll cover in just one moment. So what you see, if you look at that language in the ladder that I described, is you see a very, very careful adherence to directional neutrality. You see symmetry. You see a process that is described from 3 all the way through 9, starting with the beginning, working through the intermediate steps, and finishing with the ballot right before the election. So there's a timeline that's built into that ladder as well. Just like when you go up a ladder, I think there's even a sticker on it that says you have to don't skip rungs. And so the legislature drafted it just that way. It's very logical.
Well, that might be the case, but why doesn't 10, under your reasoning, reference subsections 3 through 9, but instead only reference 1?
Okay, so here's where it gets crazy. I would argue that it does. And in order to show you, and again, I think once you see it, it's really hard to unsee. And my esteemed counselor just read the whole section. I won't reread that, but I'm going to focus on these magical words. By following the same procedure outlined in subsection 3. There are words in that phrase that become surplusage if we interpret it to mean only follow the requirements of subsection 3. In fact, you could probably strike that entire phrase if you wanted to get to the meaning of only following subsection 3. So they could have said by complying with subsection 3.
Did the trial court consider subsection 10 in its ruling below?
I don't believe that the trial court mentioned subsection 10 in its ruling. I think the trial court focused on subsection 9 correctly. And
Let's
that's
digress
because
back to the jurisdictional issue, if you will. Did the trial court essentially acknowledge that it was issuing an advisory opinion when it observed that applicants could seek declaratory relief after the election if the referendum passed?
that comment was, in the trial court's order dicta because it followed a very explicit sentence saying that the ballot language did not comply with the statute, and that was not hypothetical and was not advisory. So if you look back at that language I was just focusing on,
Go ahead.
by following the same procedure, what does that mean, the same? Why not just say the procedure, the same procedure? So that's one interesting statutory interpretation question. The second point is they used the word outlined. Not by following the same procedure in subsection 3, but the same procedure outlined in subsection 3. What does outlined mean? What is an outline? An outline is an overview. And if you look at subsection 3, and in particular subsection 3A, you will see that's the one where it describes the county initiating the process. That sentence ends in referencing the word ballot.
But why is it more reasonable interpretation of subsection 9A to be that it applies only when the county is attempting to go from an at-large system to a single-member representation?
Well, Your Honor, I think for all the reasons that I just mentioned, I believe that the language in subsection 9 is expressly bidirectional. And to supplement that, to give you more evidence that I'm right, and I think you'll agree with me, if you look at subsection 5, where it outlines the language for petitions, that is in citizen-initiated processes, it is also bidirectional. So it works for either way.
But isn't subsection 10 the only provision in section 124.111 that expressly addresses when a county wishes to revert to an at-large voting system?
I'm sorry, Your Honor, I didn't
I'll
catch.
repeat the question. Isn't subsection 10 the only provision in section 124.011 that expressly addresses when a county wishes to revert to an at-large system of voting?
Did you say expressly?
Yes.
Okay.
That expressly addresses when a county wishes to revert to an at-large system of voting.
Yeah, I would agree. That's the only spot in that section where it expressly refers to reversion to at-large. But I would argue that subsections 3 through 9 all implicitly address it.
Can I ask, I mean, instead, I'll be honest, I find this argument to be your weakest argument. The one that I'm actually interested in is what I was asking your opposing counsel just before. Is there any special status? So this, I mean, I know that the voters had to approve it. That's, Article 3 allows for that, and the legislature provided as a condition for the charter amendment to go into effect. It had to face the voters first, and it was approved and added to the charter. But that's still the legislature directly amending the charter via special act. Do you think there's any special status to that kind of amendment to the charter versus a county commission approved charter or proposed charter amendment that goes to the voters? Otherwise, like, what's to prevent a biannual back and forth between the county commission and the legislature? And I think that there are reasons for why the legislature did what it did, and it has the authority to circumvent the county commission, arguably. That's why Article 3, Section 8 has an exception for charter counties. Otherwise, we're in this situation where every 2 years, so the legislature passes another amendment to the charter, and then the county commission, and it's approved, and then the county commission comes back and puts it back to the voters the other way, and you're just going back and forth.
Yes.
But is there any legal authority to place a legislative amendment to the charter in some sort of special status?
Your Honor, I apologize. That wasn't a direct issue in the case, in this appeal, so I didn't dig into that. I share your questions about those issues. I would say that this court doesn't need to reach the outer boundaries of what HB 1493 accomplished, or what the state's preemptive powers were with regard to HB 1493. The only issue I think that this court needs to reach with regard to this appeal, and this goes to our third Tipsy Coachman argument, is did the local government subvert the state's implied intent by immediately reversing the voting method in Alachua County?
Well, that's why I'm asking. I mean, you did argue it in the...
Right, and let me approach it this way. Perhaps it violated the spirit of the special law, but how did it violate the law itself? I mean, I think you acknowledge in your answer brief that 10, the reversion component of the statute's still in place, right? The trial court said that as much.
I don't think that in good faith we could argue that that HB 1493 intended to preclude for all time the county's ability to revert. But the state obviously wanted Alachua County citizens to enjoy the benefits of single-member districts for some period of time. The question is, and I think that Alachua County is implying that because there's no explicit language forbidding them from doing what they did, then it's okay. But that shifts a burden onto the state that might be too much of a burden. The state's not required to anticipate every way that a local government could get around or subvert its intent. That's just an impossible burden. So, in any case, if the county did any kinds of dirty work at the crossroads or whatever, that's, our point of view, we would be right back here in the county, would be making the same argument. Well, HB 1493 doesn't say we couldn't do this. So that's why implied preemption exists, I believe, so that we can look at the reasonable intent of the state's action and compare it to the local government's conduct to determine whether there's been an illegal subversion.
But I'm still not getting how 124.011, the entire process could apply in a situation. I mean, 124.011 was designed, as you, I think as both counsel explained, it was designed to facilitate counties going to single member districts at a time when There were no counties that had single-member districts, and this was a process they had to go through. Okay, that's fine. But that's not this situation. In fact, you have a situation here where the legislature told the county, we're amending your charter. And that's the way it's going to be, subject to the vote of the, subject to a referendum. But assuming the voters approve, that's the law in the county. So even though it faced a referendum, and even though it is effectuated as an amendment to the charter, it is still a special law. It has, it's in the books in the Department of State. It's an extant special law, which seems to me to be in place until the legislature repeals it.
Correct. I agree.
In fact, the Florida statutes, the Adoption Act, it accepts special laws from being repealed. So it is still in effect. And how can it be that a county commission could override a special act by ordinance?
We don't believe that it can, is the short answer. We believe that it was a subversion of the statute. The challenge is that the county has, invoked this statutory process that isn't directly
Sure.
referred to in HB 14.
And so getting to that, you did obtain a judgment from the trial court, and it said that the proposition is invalid. But it passed. What is the status, what does that judgment mean? What is the effect now? And I'm assuming you did not seek any supplemental relief, or maybe you did. You're not seeking any review of that. So what's going on?
Yeah, so I believe that the trial court's order explicitly provides that in the event the voters approve the reversion, that we can seek additional relief in joining the supervisor of elections, or getting some other post-election or prior next election relief. But
there has not been an election yet under the.
next year.
Okay.
The results of this election are suspect because they were clouded by the judicial decision that was well known in the community. So who knows how many voters didn't turn out because they relied on this judicial order.
Counsel, I'd like to digress for a moment back to the appellant's statutory interpretation argument. If the legislature wished for any provision other than subsection 3 to apply to a change from single member to at-large, wouldn't it have said that in subsection 10?
I believe that it did say it. I believe it said it when it used those magic words that I told you about, that would be surplusage if we interpret it any other way. And that is by following the same procedure as outlined in subsection 3. That's where I think it was in the answer to your question. Regardless, I see I only have 1 minute left. If there are no further questions from the panel, I would like to thank you very much for having this opportunity to be here in this beautiful courthouse. And have a good afternoon.
Thank you, counsel.
Judge Tannenbaum, first, with regard to your concerns regarding whether the county could revert to single-member district voting notwithstanding the special act, all I can do is emphasize that the petitioners have said that the trial court correctly concluded that the county could return to at-large voting by using the mechanism in 124.01110. They've not challenged that below or here. In fact, they say that was correct. They've clearly waived that argument. In addition, it's noteworthy that amicus, which claimed to have had a role in both the passage of the special act and in the 2022 referendum campaign, also acknowledges that the county can revert to at-large voting by the procedure in 124.01.110. Now, with regard to the statutory construction issue, let me just say the language of subsection 10 couldn't be clearer. It uses section in the first part of the subsection, but uses subsection 3 in the second part. And it says the procedure in subsection 3. The procedure in subsection 3, all you have to do is read subsection 3, and it says that the proposition can be put on the ballot by one of two manners. That's the procedure they're talking about, either by a formal resolution adopted by the Board of Commissioners or by citizen initiative. Finally, let me just say, there is no way you get to the result petitioners want you to get to on the statutory construction issue without ignoring the plain language of subsection 10 and instead inserting for subsection 3 in subsection 10 the word section. Thank you.
Can I ask?
Yes.
So do you deny that a special act of the legislature has the same status of law as a general act?
I think in general, the law in Florida considers the two as two different things. If you look at Article 8, Section 1 of the Florida Constitution, you'll see that the first sentence of 1G talks about general or special laws, but the second sentence, the very next sentence, just refers to general law. The sentence that says they can pass ordinances that aren't inconsistent with general law.
And that's one of the special statuses of a charter county as opposed to an
It is, yes,
non-charter
sir.
county.
Thank you.
And thank you, counsel, for your respective oral arguments.